Good afternoon, everyone. Welcome. Thank you for being here today. We Today is Why Class Actions Matter: Empowering the Public to Hold Corporations Accountable, presented by Brad Moore. My name is Cassie Slugich, and I am the Outreach Director here at the Stritmatter Law. Founded in 1945 in Hoquiam, Washington, we are proud to continue serving the community where our story began, while also operating our main office here in Seattle. Over the decades, three of our senior partners have served as presidents of the Washington State Association for Justice, and our namesake, Paul Stritmatter, served as the president of the Washington State Bar Association. The WSBA has licensed Stritmatter Law as a sponsor for mandatory continuing legal education credits. So today's webinar has been approved for one law and legal credit, at which time at the end of the webinar, you'll see me again and I'll be asking you to confirm your bar number for a credit. Please feel free to enter any questions into the chat box or Q&A box. Our presenter today is Brad Moore. Brad is senior partner at Stritmatter Law, who has handled many consumer class actions over his 33-year legal career. Nearly all his class action work has involved CPA violations by large corporations and insurance companies, typically involving individually small claims brought by consumers. So please join me in welcoming Brad.
And it's a little weird for me because I can't see anybody, but I know you're out there. So I'd like to say, first of all, very much appreciate you taking time away from your day and your summer on such a lovely day to participate and be part of this CLE about class actions and why they matter. I don't know how many folks out there have actually pursued a consumer class action. If you have, then this is probably not news to any of you. If you haven't, then maybe this will be somewhat educational for you and you can learn a few things. I guess the first thing I'd like to do is just kind of give you a brief history before I dive into why class actions matter. The original federal rule, excuse me, was adopted in 1938. Washington adopted a similar Federal Rule of Civil Procedure 23 as CR 23 in 1967. So the rule was intended to consolidate the existing equity practice of class actions. And it distinguished between true, hybrid, and spurious class actions based on the nature of the rights involved. And then in 1966, amendments took place, and the major overhaul there was changing it from an opt-in class to opt-out. So there was an introduction of the opt-out mechanism for B3 classes, typically involving money damages. And that, of course, meant that individuals were automatically included in the class unless they actively chose to be excluded. There are some derivations of that under federal employment law where you have opt-out classes, but it's technically not called a class action. It's a collective action. Not that the difference makes, not that that is a big difference, but in any event, that was a distinction that was adopted as an amendment to FRCP 23 in 1966. And then in that amendment basically was a boon for plaintiffs because it allowed for more efficient and widespread litigation of claims affecting large groups of people, though it did raise some concerns about potential abuse because the rights of absent class members may or could have been trampled on. So the debate over whether we should have gone to, we being the federal bar and the state of Washington, the ongoing debate about whether it was appropriate to have opt-out only classes. And then there were some further developments in 1998 where class certification motions, if decided in favor of the plaintiffs, could be immediately taken up for interlocutory review. So that's kind of like a brief history. I guess I could ask for a raise of hands, but I can't see anybody, whether you're familiar with CR 23 in the state of Washington. If you've handled class actions, then you know exactly what that is. Why do they matter? Well, I guess I fall down on the side or the argument that it's probably the most powerful legal tool for protecting the rights of individuals against large, well-resourced defendants like big corporations. And as we'll talk briefly in a little bit, or as I'll mention briefly in a little bit, including against the government, and in particular in the age of executive order wielding Donald Trump, class actions may be the only way to challenge his executive orders that are applicable on a nationwide basis. So clearly, class actions are important and become a powerful tool because most people can't bring small claims because the cost to pursue them would be just prohibitive. Let's just say, for the sake of argument, you have a company that's literally stealing small amounts of money from you, and you want to get your money back. How are you going to do that? The filing fee could be more than what you would get back, even if you wanted to go after them. So people just let it go. So while a single person would not be able to pursue a case worth a few hundred or thousands of dollars, when combined with hundreds of more or thousands of others who are in the same situation, it does become economically viable. It levels the playing field, obviously, between everyday people and powerful corporations and the government. And it allows wronged individuals to seek redress they otherwise couldn't afford. It's also important to have class actions because it allows for corporate and government accountability and deterrence. When a company, for example, engages in widespread harm, whether it's deceptive practices, wage theft, defective products, data breaches, TPCA cases, class actions expose and stop that misconduct. They deter future wrongdoing by imposing real financial consequences, and it pressures the government and companies to reform unlawful practices. It's also important because it leads to judicial efficiency. You can imagine having thousands of very small claims flood the court system. That's just not efficient. So having one plaintiff or two plaintiffs as putative class members pursuing claims on behalf of thousands, that is a much more efficient way to deal with things. It saves time, resources, and also it avoids potentially inconsistent outcomes. You can imagine two claims, small claims, going to court, separate courtrooms, and having a jury or a judge reach a different conclusion. And that is one of the things that class actions is supposed to help to eliminate. You also want the outcomes to be uniform, right? Especially when different judges and juries might reach different results. And the defendants in those situations, whether it's a corporation or the government, could exploit the inconsistencies in those individually decided claims. So many, and also enforcing the rights that might otherwise be ignored is another important reason why we have class action. Many laws, especially Consumer Protection Act, employment, antitrust, civil rights, that sort of thing, provides for private enforcement of those laws, where there might be regulatory agencies that would be charged with pursuing those on behalf of those folks, but they just don't have the resources to investigate and prosecute every violation. So it's a backstop when regulators are underfunded or unresponsive. So one of the things I wanted to talk about was a case that my partner, Andrew Ackley, is pursuing currently. It's a great example of the importance and why class actions matter. It's in the area of the very sexy topic of subrogation. And we all have to deal with subrogation in the state of Washington, whether it's private insurance plan, whether it's PIP, we have to deal with subrogation. And we all know the difference between Washington law, which applies the made whole rule, and ERISA, which typically does not allow for the made whole rule to have any bearing on how much the plan will recover. Typically, in ERISA plan situation, subrogation is a 100% on the dollar return to the insurance company. So the multi-plan case involves a pharmacist, government employee pharmacist, who was hit in a crosswalk and was severely injured. Just checking something here. She had a UIM plan that called for $250,000 in UIM limits. Initially, she was not represented by counsel. She was covered through a regents plan through her employer. And as soon as she asked for those UIM limits of 250,000, her insurance plan, which kind of like Rawlings, you've seen some of these outfits that they hire folks to get their money back, the insurance company's money back when they pay benefits resulting from somebody else's negligence. And Multiplan sent a notice of ERISA lien to Safeco. And as I mentioned, of course, typically ERISA plans receive first dollar, and that's thanks to the Supreme Court's decision in the U.S. Airways versus McCutcheon case. And it doesn't, nobody cares. I mean, at least if you're an ERISA plan, they don't have to provide any relief on their subrogation. They don't care if the made whole rule applies because it doesn't apply in federal law. But as we probably know, government plans are not subject to ERISA because of 29 USC section 1002. They are expressly excluded from ERISA. So local government plans are expressly excluded from ERISA, and that means the made whole rule would have to apply, assuming the plaintiff, or I guess the claimant in that case, the UIM claimant, was not made whole. So the claimant, the person who was injured in the crosswalk, contacts Multiplan. As I said, she does not have an attorney, and the plan, Regents, requests a 50-50 split of the UIM benefits, even though they don't provide any ledger, no list of what they paid, or other proof that its payments reached half of that amount, or $125,000. So a couple days later, Multiplan emails the injured person and says, quote, "Your health insurance plan, exclusively controlled by Regents, is a self-funded ERISA plan and governed by federal law. Thuringer, the made whole rule, does not apply in this matter." That is a blatant misrepresentation of the law. She's still unrepresented. And finally, she does hire a lawyer, Andrew Ackley, and Andrew rightly points out that they're not an ERISA plan, and waive your subrogation or waive any right to any reimbursement because of the made whole rule, and they capitulated. So the litigation goes forward, and Andrew moves for class certification under CR 23C4A, which is an issue class certification, essentially arguing that the representations made by Multiplan violated the Consumer Protection Act, which seems almost obvious that they did. Also seeks CR 23B2 injunctive and or declaratory relief, basically saying you can't do this going forward. You can't misrepresent when you're dealing with government health plans that they are subject to ERISA when they are not by operation of federal law. So he currently, right now, the class has been certified under the issue of Consumer Protection Act liability, and now it's in the point in the case where summary judgment has been filed, asking the court to rule as a matter of law that this conduct on behalf of Multiplan, or the Multiplan's conduct, violated the CPA. That has not been decided yet. Incidentally, and I'll talk a little bit just the nuts and bolts of class certification rules, but this class is not one of these multi-thousands of people classes. It's about 150 government employees who submitted bills for payment through Regents that Multiplan then Multiplan told these folks that they were subject to ERISA and that the made whole rule did not apply. Again, that's a misrepresentation of law in any event. So under CR 23B2, which is the injunctive declaratory relief part of the rule, a court may certify a class when the party opposing the class has acted or refused to act on grounds generally applicable to the class, thereby making appropriate final injunctive relief or corresponding declaratory relief with respect to the class as a whole. And this is a perfect case for that, right? This is a blatant misrepresentation of the law. And if the court certifies a class, it'll apply class-wide, and Multiplan will no longer be able to make these misrepresentations about whether it's subject to ERISA or not. So the rule, as I think any of you who handle class actions knows, you have to have four prerequisites to class certification. And it's numerosity, commonality, typicality, and adequacy. So if the class is so numerous so you have to show that the class is so numerous that joinder of all the members is impractical. You have to show that there are questions of law or fact common to the class, and the claims or defenses of the representative parties are typical of the claims or defenses of the class. And then lastly, you have to have adequacy, and that basically means that the representative parties, including counsel, will fairly and adequately protect the interests of the class. So, in talking about numerosity, plaintiffs need not show that it would be impossible to join all proposed class members, but that it would be extremely difficult or inconvenient. And as it relates to commonality, there's a low threshold to satisfy the test of commonality, which is qualitative rather than quantitative. That is, there need be only a single issue common to all class members. Typicality is satisfied if the claim arises from the same event or practice or course of conduct that gives rise to the claims of other class members, and if the representative's claims are based on the same legal theory. So this is just sort of black letter class action CR 23 stuff. And then when I talked about adequacy, so where a proposed class representative possesses the same interest as the class and has suffered the same injury as every class member, he or she meets the adequacy requirement. Now, one thing that I should point out is there may be different damages amounts that each plaintiff or each class member, I should say, has sustained. That's not an impediment to class certification. In fact, in the Multiplan case, we're going to have 150 different amounts of damage because not everybody suffered the same although the representation was illegal and in violation of the Consumer Protection Act, at least in our view. Everybody did not have the same amount of medical care, and some folks may or may not have been made whole. In any event, there may be differences as to the damages, and that's not an impediment to class certification. When I say adequacy, protection of the class, a class member has a duty not to self-deal. In other words, they have to literally try to protect every member of the class. And so trying to squeeze more for themselves at the expense of the class is something that's not allowed for a class representative. And then when I mentioned counsel also has to be adequate so that they can protect the interests of the absent class members. And so if there's no conflict of interest, and that class rep is going to vigorously prosecute all the claims on behalf of the class, then that person can serve as a class representative. All right, so that's sort of the brief outline of why I think class actions are very important, and we should be pursuing them. There is some bad news. And I'm not sure that that folks know this, but if you get calls from somebody and they say, okay, I got my cell phone bill and I noticed there's a charge on there for $12.18, and I don't know what that's for. I didn't authorize it. Or if you have a cable bill and they say you charged for a movie or you watched a movie and you didn't, and they've charged you for that. If you want to sue as a class or sue the company, the cable company, or even a bank, or any of these companies that I mean, you've heard of these things, right? They kind of try to steal small amounts of money from you. You will most likely not be able to go after that company for anything as a practical matter, because there will be inside of all of those terms and conditions that I know, all read when you click the little box saying you've read the terms and conditions, will have a clause in it or two. One of those clauses will require that if you have any dispute arising out of any of this, the service or in any of your dealings with the company, it will require that you go after your damages as you see them only in a binding arbitration. So they have a forced arbitration clause in those terms and conditions. And there is also you have to only pursue it in arbitration as an individual. You cannot do it as a member of a class or as a class representative. Now, you would think that would be wholly unfair, that somebody who's been overreached by their cell carrier or by the bank, uh, if that happens to them, that it would be unfair that they'd have to pursue this thing at an individual basis in a binding arbitration, because the arbitration oftentimes would be more expensive to pursue than the amount of the claim, if you kind of talked about at the beginning. Well, the United States Supreme Court, in the Italian Colors versus American Express case, a decision that was authored by Anton Scalia, basically, and in that case, it was Italian Colors had an arbitration, had an agreement with American Express when they were accepting payment by allowing their customers to use American Express cards. There was a clause in there that said you have to arbitrate if there's a dispute between you and American Express. And I think the amount that was in controversy in that case was a few $1,000s. It wasn't a lot. And Scalia, of course, the plaintiffs in that case made the argument, well, we don't have any way to get our money back. It's going to cost us more to pursue an arbitration than we have been stolen from, basically, that the amount that American Express was taking from Italian Colors was not as much as that would cost them to try to get it back. And while the court recognized that that may be a reality, Justice Scalia basically said that if there was any conceivable way to vindicate your rights, then that's good enough, and those clauses are enforceable, and enforced it in that case, and that sort of set the bar for anyone trying to pursue an a class action in any context where there are clauses in the terms and conditions. And again, I don't think any of you have ever, when you update your Apple software, you just click the little box that I've read and agree to the terms. Nobody reads that stuff, but if you go back and look at any of them, and almost all of them are just clickbait, right? You just go click a box and move on. Those things are enforceable. So I get calls from folks sometimes and they say, hey, look, I have this case. I got charged a fee that I wasn't supposed to be charged. And I think this is happening frequently. And I heard from other folks that they get charged the same fee and we never agreed to it, et cetera. I want to sue Verizon for whatever reason because of this theft of a small amount of money. I have to tell them, sadly, that they're out of luck, that those arbitration clauses and class action bans are enforceable provisions in those terms and conditions, even if you haven't read them and even if they're buried. It's almost impossible to get out from under a forced arbitration class action ban clause. And some of these companies are getting extremely clever, although, I mention when I say clever, they haven't been enforced, but there are businesses that will have a placard posted on the outside of the building, and as you go in, supposedly you're supposed to read the plaque, and in very small print, it'll have if you enter the store and do business with us, I'm making up the exact words, but words to the effect of this, then you can only come after us through a forced arbitration clause, and you can only do it on an individual basis, not as a class. They'll have companies will use inserts in their products that'll have similar language to that. In both of those instances I know of, the courts did not enforce that, but they're trying to get as creative as they can in trying to prevent people from bringing these class actions because, well, I guess it's good for their business, but not good for consumers. So the other bad, or sorry, should say good news. Um, as you remember, Donald Trump signed an executive order early in his second term here that undid or purported to undo birthright citizenship. And that executive order was challenged by a person who was born in the United States to an undocumented mother. And the court, the underlying court, the federal court, issued a nationwide injunction. So it was not a class action. It was a class action. But it all started because the Supreme Court in the Trump versus Casa case in a 6-3 decision held that federal courts lack the authority to issue nationwide injunctions under the Judiciary Act of 1789. And the court partially stayed the nationwide injunctions by 3 district courts that had thrown out Donald Trump's executive order targeting birthright citizenship. But the court said that the Judiciary Act provides that federal courts have jurisdiction over all suits in equity. So as previously held by the court, that encompassed only the sorts of equitable remedies traditionally, this is a quote, traditionally accorded by courts of equity at the country's inception. Nationwide injunctions, the court went on to hold, are not sufficiently analogous to any relief available in the High Court of Chancery in England or founding era courts of equity in the United States. So what that did, that was the bad news. I guess what that did, though, is prompt folks in multiple states now to filing a class action to have the court issue a nationwide class, basically seeking injunctive relief. So I think that's where it's headed, although I'm not sure how the U.S. Supreme Court will deal with that issue. I mean, it's squarely within the rules, FRCP 323, to move for an injunctive class under the rules. So there you go. The other sort of, I don't want to say bad news, but it is the reality of several years, many years, I guess now, ago, the Congress passed the Class Action Fairness Act, where any class action that's filed in state court where what's at controversy is $5 million or more, they can remove the case to federal court. And of course, when you get into federal court, you have to deal with all its quirks, including a unanimous verdict. And that can be problematic. And then sometimes judges are very hostile to class actions. And essentially, I don't know why, because of all the reasons we talked about it, or at least I mentioned at the beginning, access to justice, the corporate accountability and deference, efficiency, uniformity of outcomes, and enforcing rights that might otherwise be ignored. So all those things are very important. That's why class actions matter. And now I'm thinking about it, I don't have anything else left to say. I can answer questions if you folks have any. I don't see anybody asking questions. Cassie, what do you think?
Let's see here. Does anyone have any questions? You can type it in or raise your hand, and I can click on you and you can speak directly to Brad.
Oh, I guess one other thing I wanted to mention was in the multi-plan case, There, as I mentioned, a summary judgment motion on whether or not multi-plan breached the Consumer Protection Act. There are some other claims that are part of that case, which are not currently subject or set up for summary resolution. But the insurer, not really insurer, but multi-plan, the sort of plans um, collection agency, has filed a motion for summary judgment on punitive damages. Because there's a difference between Washington law. Obviously, we don't have punitive damages in Washington. Illinois, where multi-plan is headquartered, does have punitive damages, and they are trying to argue that Washington law applies here, not Illinois law. And it goes to whether there's evidence of intentionality on the misrepresentations that were made, because you can have a CPA violation but not have, intent or intentional misconduct. Um, and I think there's going to be some additional discovery on that. The response from our side is that we need to do some 56F discovery. So we'll see. There's also a fraud claim in that case, and keep your eyes open. Stay tuned.
There's a question in the
Yeah.
Q&A box. Do you see that? Or there's a couple
Is
now.
there any action that is going on or contemplated against Datavent Seahawks and their attempts to override the limitations in medical records, billing, production fees? I don't know about that litigation. If it's in the state of Washington, I'm not aware of it. If it's outside the state of Washington, I probably wouldn't be. I guess I'm supposed to type my answer though, huh? That's as fast as I could type. Yeah. So the other question here is, anyone attacked the placard exclusion clauses as adhesion contracts? And the answer is, yes, they have, and that's one of the reasons why they were not enforced, because first of all, it's people don't look at placards as they walk into a store. I think Walmart tried to do that, and then they stopped doing that. And then there has been, or was, a challenge, a successful challenge to one of the home building supply um, products. I think it was shingles, asphalt shingles. They came in a big package, and there was something printed on the packaging that said, if there's a defect in this product, then you have to go after us or resolve any dispute about it through binding arbitration. And there was a class action ban as well, and that was not enforced for very similar reasons. It's an exclusion clause. You buy the product and then you find out you've just given away your rights to a jury trial. So that's not enforceable. And I mean, there's been a whole bunch of litigation about unconscionability of these clauses, and largely those challenges have failed. Unfortunately, they just haven't. Okay, outline the cost and attorney fee it takes to get through the class certification stage of litigation. Okay, so the question is, can you please outline the cost and attorney and staff time it takes to get through the class certification stage of litigation, and how discovery works at that stage? Sure. So the cost and attorney, so typically in a regular PI case, we all know that we as lawyers can't tell our client, you're not responsible for the costs at the end of the day. If we lose the case, you still have to reimburse us for our costs. The reality of what happens in that scenario, I think we all know, but in a class action setting, you can tell your class representatives that they are not responsible for the costs in the case. So if there is a loss, they do not have to be, they don't have to reimburse us for costs. And as far as attorney time and staff time, it really just, it varies, right? So you do class discovery before you do merits discovery in many cases. So you'll have a case, we file a class cert motion, and then you do discovery over, well, you usually do the discovery first, then you file your class certification motion. And it just varies by case. It depends on the scenario. So I wish Andrew could tell us. I don't remember off the top of my head how much time it took to get to this stage where he does have a certified class. Um, So discovery through that would be as I mentioned, typicality, commonality, adequacy of representation of both the class representative and the lawyers. So they will typically depose the class reps to find out what their motives are and if they understand what their role is and all that sort of thing. And then also if there's any issue, like in the multi-plan case, there wasn't a whole lot of class discovery other than as it relates to the representations made by multi-plan when they're dealing with government insurance plans, and they're saying that they're subject to ERISA. But it's just gonna vary from one case to the next. Okay. Yes. Okay. So what is the biggest challenge when bringing a class action? The biggest challenge almost always is one that the defendants, the corporations or the government raises, and that is that there are too many individual questions of fact or law such that class action vehicle would not be an appropriate way to deal with it. Everybody's slightly in a different position. They're the way they were dealt with was slightly different. If you're doing a case involving sort of deceptive practices, they'll say, well, these people were aware of what was happening and they didn't care or they didn't object. And so it's always the challenge on commonality, typicality, vis-a-vis the individual questions of fact that trip up class certification motions. And I think the other thing that's a big hurdle is trying to educate judges on what the class action vehicle is supposed to do. And as we've been talking about, why it matters to have them, especially when you've got a corporation doing a particular or engaging in particular conduct that affects large groups of people and it may affect them differently. It may affect one person who would be a member of that class slightly differently than another member of that class, but the conduct is the same, and the conduct has been equally dished out to everybody in that class. So I think it's educating judges, overcoming the individual questions of fact that are the two biggest challenges to certification. When you're doing an injunctive class, though, that's usually pretty easy. So, for example, in the 14th Amendment birthright citizenship executive order motion for class certification that was filed in several states, that's pretty easy. It's just the question of does the Constitution say what it says or it doesn't? And if it says what it says, and I'm a class rep, then I should be able to get a decision from a court saying it applies to everybody who is born in the United States because the Constitution says what it says. Those are the easier types of class actions. I can think back to one where I sued a home developer it was a class action over the use of galvanized nails to put on the siding to the homes they were building when they should have been using hot dipped galvanized nails. And this, again, trying to educate judges, filed the case in Pierce County, and the judge in that case denied class certification, basically saying that everybody's damage to their siding was different. And so there were too many individual questions of whether it was the nail that caused the rusting or whether the nail didn't cause any rusting. And he got all caught up in the fact that that's not what we were going after. Ultimately, we got the case certified in King County, and it resolved after we did damages discovery. Basically, they kind of admitted they used the wrong nail, but we had to figure out what each homeowner needed in order to remedy the bad nail that they'd used. Any other questions? Sorry if that didn't answer your question, but I think it did.
All right. I'm going to push a poll through so you can enter your bar number. Let's see if that works. If it doesn't, just enter it into the chat. Either way, if anyone has any other questions for Brad,
Yeah,
let us
I'm
know.
happy to.
All right, it looks like it's going. Thank you so much, Brad, for your presentation. Oh wait, we do have a hand raised. Let's see. Andrew, do you want to? Okay, I'm not sure when he rose his hand, but let me allow him to talk. Andrew Lemon has a comment.
Oh, okay. Yeah, okay.
Good job. Enjoyed it.
Thank you, Andrew Lemon. Good to hear your voice.
Hopefully, I'll see your smiling face soon.
Yes, sir.
All right.
Okay,
Oh,
I
I
got
see
a
one
question.
more question in
How to
the.
start. Any advice to a young lawyer about how to start working on class actions? Um, wow, that's a tough one. I guess the big, somebody asked a question, so I'm going to answer the question a slightly different way. There are oftentimes great potential class action cases out there. And by the way, most of my class actions in the Consumer Protection Act area have been against insurance companies, and they don't get to put um, our forced arbitration clauses or class action bans in the insurance contract because they wouldn't be allowed by the insurance commissioner. So that's why I go after them. So one thing you could look for as a young lawyer and trying to get into class action work is to look at your clients in the personal injury context and their interactions with their insurers, because oftentimes what these insurance companies will do is they'll repeat the conduct that's clearly in violation of the Consumer Protection Act. And if they are doing it to your client, they're probably doing it to lots of other people. And that can turn into a class. So keep your eyes open for abuses in the PIP context, in the auto parts or auto repair context where they're trying to screw your client over on diminished value or some other thing. And then I guess the other impediment to class actions, sort of answered a slightly different way, is that there are oftentimes really good potential class actions out there, and you see the misconduct and you know that it violates either Consumer Protection Act or some law, whether it's a wage and hour law or some other thing, but you don't have a client. You can't find a potential class member. You may have been a victim of one of these things yourself. Um, but in any event, sometimes finding a class member in a really good case, what looks like a good case, it doesn't go anywhere because you can't find anybody. And the best way to try to find somebody is to ask family members, friends, even some of your clients, former clients, and whatnot. Just outline the misconduct and see if they have anybody they know that's experienced it. Yeah, okay. Sorry, Cassie, I was just saying, are we supposed to put our bar numbers in the chat or?
Either way, yeah, in the chat or in the poll, you can enter it.
Great.
All right. Any more questions for Brad? Looks good. All right.
Oh, I'm sorry.
Oh,
I'm going to respond because
okay.
uh, Jim says this is frustrating. Is there no remedy for the wrong of corporations screwing people? There is, but the folks that draft their terms and conditions are really quite good at putting that language in. And if they don't, it's almost legal malpractice on whoever the corporation hired to draft their terms and conditions, because we know that they're enforceable. These forced arbitration clauses and class action bans, they have a constitutional right to a trial by jury, but the courts have turned that thing on its head and allowed for these forced arbitration clauses. I mean, I guess there's some good news in that some of these folks will be able to get some remedy by way of arbitration if certain monetary thresholds are not met. So for really small claims, the some of the companies will actually pay for the arbitration. I still think that's unsatisfactory, but in any event, yeah, there's not a whole lot we can do. They can literally steal small amounts of money from thousands and thousands of people, and there's really no effective remedy, with the exception if you have a consumer protection division of your state's attorney general office. They can go after these corporations or hire you as a assigned counsel to pursue the CPA claims in those contexts without regard to the forced arbitration clause or class action ban, because the attorney general is not a party to those terms and conditions and didn't contract with anyone. So you would be going after as a special attorney general. But it's hard to get that division to relinquish its authority to go after companies that violate consumer protection laws. They don't seem like they want to do that very often. I can't think of the last example where they did. Any other questions or comments?
Okay, thank you so much for joining us today. Be sure to put your bar numbers in the chat. It looks like we have everyone. So thank you so much. Thank you, Brad, for the great
Hey,
presentation.
you.
We do have two CLEs coming up in August and September. We have them every month, so be on the lookout. And please fill out the survey that you will receive as soon as this CLE is concluded. Thank you so much for joining us. Bye.
Everybody.